I'll start from first. So, hi everyone, welcome to another session. Today, we are going to learn about Memorandum of Association. So, one second. Kindly hold on and kindly ask no one to join again because it is late. So, it will disturb my class. And the screen recording is, it is, about those things. I'm using a software called OBS. And definitely, yeah. So, yeah. So, very good evening, everyone. Today, we are going to learn about Memorandum of Association. Memorandum of Association. MOA. Okay, MOA. So, what exactly Memorandum of Association? Memorandum of Association is the charter. Okay, charter of a company. Charter of a company. So, what is charter actually? Charter is a legal document, a document in writing, okay, about what exactly a company is or company. Like a company is doing. Okay, so that is what exactly charter of a company, and the memorandum of association should be signed by the registrar of a company, right? It should be signed by. It is a document signed by registrar of a company. Okay, and it is the dominant instrument and it defines the limits of the company. Limits. It will determine the limits of the company. All right, limits of the company. It will determines the limits of the company. It is called as ultra virus. Okay, it is called as ultra virus. What is ultra virus? It is beyond the scope of limit. So a company cannot go beyond the scope of limit. Is called as a limit, the limits of the company. So the act of the company beyond the limit of its power and object as defined as its memorandum will be ultra virus and void. So if a company goes beyond, its limitation, or memorandum of article, then it is called as ultra virus. So memorandum of association is what exactly a charter, and it is a signed document by the registrar of company, and it will limits the company to operate. There is a scope of the company, and it will limits the company to operate in a confined area of operations. If a company is going beyond the memorandum of association, then the company is said to be ultra virus. So the memorandum of a company is the constitution of a company. So as you all know what exactly constitution is. So Indian constitution, you know about Indian constitution. Constitution, with the help of the constitution, our lawmakers are making law, right? With the help of the constitution. So if the law making authority is violating the constitution or go beyond the constitution, or which is not comply, the new laws are not comply with the fundamental rights, fundamental duties, other directive principle of state policy, definitely that law will can be reviewed by the Supreme Court and can be abolished also. So same like that, memorandum of association is the constitution of a company. What do you mean by a constitution? Indian constitution is the key in the mind of the makers of the law, key in the minds of the makers of the law. Okay, so constitution's preamble, it is what exactly? It is the key in the minds of the makers of the law or rules. That is legislature has to learn constitution thoroughly before they come with a rules, regulation, etc. Have an example. We No one can be prohibited by, from education. Education is a fundamental right. No one can be prohibit from assembling. If it is a legal assembly in the sense like association of person coming together for certain reason. Have an example, some strike, or everyone can go for strike and all. It is a fundamental right. Okay, so so next is one second. Yes. So so there is a case called Ashbury Railway Carriage and Iron Company versus Ritchie. Okay, in 1857. So in that, the court held that the memorandum of a company is its charter and defined the limitation of the company. So we learned about those things. So in this case, what exactly the court said that? The English court said that. So memorandum of association is the charter of a company, and it defines the limitation of the company. All right, it defines the limitation of the company. So next is that there is a case called Courtman versus Brougham. So Courtman, one second. Courtman, it's not Courtman, it's Courtman versus Brougham. Okay, Courtman versus Brougham. So the court held that the purpose of a memorandum of association are twofold. The purpose is twofold. One is prospective shareholders who contemplate the investment of their saving should know the field in which it is going to be used. So it is the information. Memorandum of association is the association will give the information or details. Okay, details of the shareholders' money. So how the shareholders' money to be used. So shareholders will get an idea. So have an example. My company is leather manufacturing company, and I'm making foodwares and have an example, bags. So my shareholder will get an idea through my memorandum of association. So they are if they are buying my shares, definitely what happens? Definitely it will go to the go to this kind of a business. So I'm buying this share. Have an example, MRF. If I'm buying MRF tires share, definitely it goes to my money will use for certain purpose to manufacture, tires. Have an example, buying machineries. Okay. So if MRF tires, the memorandum of association of a MRF tires is depicted in a way that they are using shareholders money, or they are into tire making industry. If they are making milk product, definitely it is called as ultra virus. So the shareholders know about all the information regarding uh, you know what exactly the company's business. Second is, it will give information to anyone who deals with the company. So it will give all the information to all the laymen who deals with the company, whether the contract he intends to make with the company is within the objective or objects of the company. So for general public. So twofold are there. One is to shareholders to know where their money is to be spent, and to the general public, uh, those who are getting enter into the contract of the company. Have an example, MRF tires has to get into a contract with one supplier. Have an example, one supplier is X and X supplier. So the X and X supplier should know about what is the business of this company. So it is two-folded. So one is for general public and another for shareholders. All right. So next is the memorandum of a company shall be printed. It can be printed. It can be divided into paragraphs, numbered consecutively, and signed by 7 subscribers. So it shall be printed. The memorandum of association should be 1 second. So the memorandum of association should be printed format. It should be divided into paragraphs, and it should be numbered, and definitely signed by 7 subscribers. Okay. So if it is a private company, at least 2 subscribers is needed. If it is a private company, 2 subscribers, as we already know, 7 subscriber for public limited company, and minimum 2% for a private company. So the memorandum of company is to be prepared as provided in the forms given in Schedule 1. So the forms of memorandum of different companies is actually in different schedules, as per different schedules. So there are 5 schedule. Okay, there are 5 schedule in Schedule 1. There are 5 schedules. So what are the 5 schedules? There are 5 tables in Schedule 1. What are the 5 tables? Table A. So table A, what exactly table A? So table A is the form of memorandum of association of a company limited by shares. So and table B, so it is actually for limited by guarantee. Next is table C. It is like the memorandum of association of a company limited by guarantee and having share capital. So and having share capital. and having share capital. And table D is the form of memorandum of association of an unlimited company and not having a share capital. Okay, and table E is the form of memorandum of association of an unlimited company having share capital. All right. So, what exactly? So, memorandum of a company is to be prepared as provided in forms given in schedule 1. So, we have to comply with the forms which is given in schedule 1. There are different forms, okay, different tables. Okay, table A, table B, table C, table D, and table E. Okay, so that is what exactly you know the schedule 1. So next is the what are the content of a memorandum of association? Content of a memorandum of association. Okay, so the content of memorandum of association comes in section 4. So section 4 of the Companies Act 2013 states that the memorandum of a company shall contain these much of things. First one is name of a company. So what exactly name? The memorandum of a company shall state the name of the company with the last word limited in the case of a public limited, and in the last word private limited in the case of a private limited company, as you all know. So in a private company, we have to represent the company name with a PVT LTD. In the public company, for a public company, it is enough to have limited. Okay, after the name, no need of giving PUL or something like that. So the name stated in the memorandum shall not be identical with or resemble to nearly to the name of existing company. So name shall not be no shall not be an existing name, then it is like such, it is used by the company in undesirable in the option of a central government. So undesirable in the opinion of the central government. Okay, and the third one is so be such that it used by the company will constitute an offense under any law for the time being in force. So they cannot use such names. Okay. Okay, we cannot use an offensive name or offense under any law for the time being. Have an example. We cannot use a name like um, Kingfisher. It is an existing name, right? Kingfisher is an existing name. Undesirable. Have an example. Murder company private limited. Murder private limited. We cannot do that. Okay. So it is offense under any law. Okay. Have an example. Central jail company. No, we cannot do that. So this is undesirable and offense under any of the law. So Rule 8, subclause 1 of a company's incorporation rule 2014 gives guideline for determining whether a proposed name is identical with other or not. So nowadays we have a different software to check whether to know whether that particular name has been registered or not. And we cannot use the emblems of national emblems, right? Like United Nations emblem, sorry, Indian national emblem like Ashok Chakra, then international emblems like United Nations logo, then Government of India logo, then state government logo. We cannot use that for a company. So a company shall not be registered with a name which contains any word or expression which is likely to give the impression that the company is in a way connected with or having the patronage of um, the central government. Okay, the state government, and any local authority, local self government. Okay, which is constituted by central government or any state government. So a company shall not be registered with a name. Have an example. You cannot register a company like Indian Maritime University again because it is central government university, right? You cannot do that. So like such a way, we cannot uh, we cannot put a company's name like a Supreme Court of India, private Supreme Court of India, um, you know um, restaurant or something like that. We cannot do that. Okay, it is punishable actually, and we cannot the registrar of the company won't give you know certificate of incorporation. Your incorporation will be rejected. So, however, a company using such names can be registered if it has obtained previous approval of the central government. The exemption is like you have to take previous approval. Okay, so have an example. If a company is registered with a name which resembles the name of an existing company, the old company can apply to the court for injunction to restrain the new company. Okay, the court will restrain the new company from adopting the identical name. So if the name of two companies contain any word which is in common use, its use cannot be restrained. So common name, any word which is in common, so it this cannot be, it cannot be restrained. Have an example: apple. You can use Apple because it is a common name, but you cannot use Google. Okay, Google is a crooky name. Crooky name means there is no meaning. Airtel, there was no meaning, or there is no meaning in the dictionary. That is Vodafone, there is no meaning. That is called as crooky name. Apple, anyone can take Apple, but you cannot take the tagline and you know the logo, right? But you cannot use Apple computers. So Apple's name is Apple Macintosh. That is the full name, Apple Macintosh. So you can use Apple name for other products, Apple Books. You can use that because it is a common name. So there is a case. Okay, there is a case by Asiatic government security life insurance corporation limited versus New Asiatic Insurance Company. Okay, here a company was incorporated under the name of a New Asiatic Insurance Company Limited. The other company, Asiatic Government Security Life Insurance Company, which was registered earlier, filed a suit for restraining the new company from using the name on the ground that two names resemble to a large extent. So the court held that two names were not identical and the suit was dismissed because Asiatic Government Security Life Insurance Company and New Asiatic is different. Another case is Ewing, okay, versus, you know, Buttercup. Buttercup. All right. So the plaintiff was carrying on trade under the name Buttercup Dairy Company, a new company registered under the name Buttercup, uh, ice cream company. The plaintiff filed a suit for injunction. The court granted injunction because the two names are identical. Two names are identical. So the previous case, the former one has no identity. I mean, like that identity in the sense it was not identical. Okay, 1 second. Yes. So the next is what are the things we talked about the name. Next is office close. So second point in the memorandum of association should be office close. The first one is name. Okay. Second one is office close. Okay. Office close. So the memorandum of association must be mentioned the state in which the registered office of company is to be situated. So state is need a state name. Okay. So the situation of the registered office of the company determines its domicile and nationality. So in memorandum of association of the company, the office address, okay, should be full description of the office address is needed. So however, by section 12, okay, of the act, a company shall on and from the 15th day of the incorporation and all time thereafter have a registered office. So registered office is in needed from the date of registration. Within 15 days from the date of registration, they have to have an office space. So that office address should have to given in the memorandum of association. Then only the registrar of the company will sign on it. The company shall furnish to the registrar for verification. So the address and other some documents should be needed. So it's register office within a period of 30 days of the incorporation. So the verification of the registered office is to be filed in form number INC 22. That is a different thing. So the form consists of different things like we have to take the sign of the notary. So notarized copy of a lease or rent agreement should be shown. The registered document of the title of the premises of the registered office, okay, in the name of the company. Okay, so the document should be copy of the document should be signed by or notarized by the notary. Then authorization from owner is also needed. Proof of evidence of any utility service like telephone, electricity, water, showing the address of the premises in the same, tax receipt, etc. should be there. So if you want to change the registered office, have an example. after the registration, after 5 years, you have to change. So the registered office of a company may change from one place to another place in the same city, town, or village. It can change from one town to another town in the same state, change from one state to another state also, but you have to take the permission from the registrar of the company. Next is object clause. Which one? The third one is object clause. What do you mean by object clause? So the memorandum of association of every company shall clearly state the objectives of the company. So the object clause shall the objects for which the company is proposed to be incorporated. Have an example. What is the objective? To do stationery business, to do training business. Okay. So object of the company, object for which the company is proposed to be incorporated. Okay. So that is, you have to give those details in bullet points. Next is matters considered necessary for furtherance of main objectives, like main objectives is to make train people. Okay. So what are the matters considered necessary? So like training and development for human resource, training and development. So your main objective is to train people. So giving more clarity to that objective, you have to give sub points, like a training for IT people, training for government employees, training for kids. So you have to explain, you have to substantiate your points. That's it. So next is, so these are the three clauses that um, we have to incorporate. The other clause is liability clause. Okay. Liability clause. The fourth one is so what is liability clause? So if the company has done any wrong doing, okay, or company has done any wrong, definitely who is responsible? The company is responsible. So company has to mention those liability clause also. So the memorandum must contain a statement as the company of a members of the company. So the liability of the members may be limited by shares or unlimited or limited by guarantee, whatever it is. So in the case of a company limited by shares, it is to be stated in the memorandum that the liability of its members is limited to the amount unpaid, or if any, on the shares held by them. So in the case of company limited by guarantee, it is to be stated in the memorandum the amount which each member undertake to contribute to asset of the company in the event of its beginning and its wind up or wound up. So liability clause, the members liability. Okay. So members liability at the time of beginning, at the time of wound up also, or winding up. Okay. So that should be clearly mentioned. So the fifth clause is capital clause. Capital clause. So what exactly capital clause? So the memorandum shall contain the amount of share capital. So it should explain the share capital. Okay, share capital. with which the company is proposed to be registered, and the division of it into shares and a fixed amount. So par value of the shares, etc. Par value of the shares. So what is the amount of share? One share or division of shares, different shares, preference shares, equity shares, cumulative shares, non-cumulative shares. So everything should be there. And what is the source of capital also? So share can be a capital, debentures can be a capital. So source of the capital should also mention. So next, the sixth point is association and subscription clause. Association and subscription clause. Definitely, the company has to mention the association and subscription clause of a public company. So only public company has offer public invitation to subscribe their shares and debentures. So there should be at least 7 subscribers, and they should have signed, and it should be attested by the witness. So in case of a public company, at least 2% should be the subscriber and put their signature also, right? So the name and address of the subscribers. So first subscribers is a person who first subscribe the shares. So full description of subscribers of shares. So public and private. So public it is 7, it is 2. All right. So the subscriber should have given an undertaking to take shares from the company. So only public company can sell the share outside. Okay, private company cannot do that. So the number of shares each subscribers has taken, but one second, but both companies have subscribers of initial shares. Okay, mostly the owners of the company, or the authorized directors. Okay, so even though a subscriber has not taken the agreed share, he will be liable to pay the value of such shares at the time of company's winding up. Okay, so also this clause will mention about all the do's and don'ts about subscription, some rules, regulations, etc. about the subscriptions and association with the company. All right. So I am stopping it here right now. It is 5 o'clock, and we'll discuss some other things. Okay. So tomorrow in the next section we'll learn about articles of association.